All right. Again, it's 8:20 p.m. and we've been advised the jury has reached a verdict, and we'll be having the jury come in shortly. Now, I would ask that, I know there's a lot of emotion in this case on both sides, and since March 22nd of 2018 until now, if there's anybody here that does not believe that they can keep still and hold their emotions in check, now is the time to leave the courtroom. I'm going to ask that anybody in here not show any emotion and there do not be any outbursts. All right? Understood? All right. Are we ready for the jury?
Yes, Your Honor.
All right, let's bring the jury in. All right, you may be seated. Excuse me. All right, members of the jury, have you reached a verdict?
Yes, Your Honor.
All right, and would you please give the verdict and the instructions to the bailiff? All right. Mr. McCandless, please rise. We, the jury, find the defendant, Ezra J. McCandless, guilty of first-degree intentional homicide as charged in the information. And the answer to the special verdict question is yes, use a dangerous weapon. Again, you may be seated. All right, ladies and gentlemen, is this your verdict? All right. I'm going to do what's called polling the jury, and I'm going to ask each of you if this is your verdict. And I'm going to ask you by your juror number. All right, I'm going to list off your juror number, and I'd ask that you simply answer yes or no. Okay, juror number 30. Is this your verdict?
Yes.
Juror number 20, is this your verdict?
Yes.
Juror number 67, is this your verdict?
Yes.
Juror number 2, is this your verdict?
Yes.
Juror number 36, is this your verdict?
Yes.
Juror number 56, is this your verdict?
Yes.
Juror number 73, is this your verdict?
Yes.
Juror number 90, is this your verdict?
Yes.
Juror number 133, is this your verdict?
Yes.
Juror number 135, is this your verdict?
Yes.
Juror number 98, is this your verdict?
Yes.
And juror number 64, is this your verdict?
Yes.
All right. Ladies and gentlemen, I don't think there's enough gratitude I can express to you for your service in this matter, in the sense that you've devoted 3 weeks of your time and limitations on your liberty and so forth. And we do have a standard closing instruction, which I have momentarily misplaced. As you can see, we use a number of pattern instructions, and occasionally we stray off of that a little bit, improvise. But in any event, now that your service in this case is completed, some of you may have questions about the confidentiality of the proceedings. You are free to discuss the case with any person you choose. However, you do not have to discuss the case with anyone or answer any questions about it from anyone other than the court. If you do decide to discuss the case with anyone, including the media, keep in mind that your fellow jurors fully and freely stated their opinions and may not want their opinions made public. Please respect the privacy of the views of your fellow jurors. If any of you have questions for the court before leaving today, please let the bailiff know before you leave the jury room. And if you do wish to remain, and I will answer any questions you may have. Again, there are limitations on what the court can and cannot do or say. But we do have some information for you. In a case such as this, often the things that you see or hear throughout the course of the trial can have, I think that was brought up during the trial, secondary trauma. If we have some information for resources, if any of you feel that you're struggling in any way with any of the things that you've seen or heard about or had to deal with in connection with this case. So we'll provide that to you before you leave tonight. And again, if you have any other questions for us, we can help you with that. But members of the jury, on behalf of Dunn County, the court would like to express its sincerest gratitude and appreciation for your service in this case. The court recognizes that you have devoted significant time and tolerated restrictions on your normal activities during the trial. Your service is a necessary and essential part of the justice system guaranteed by the Constitution of the United States. I hope you found the experience to be a rewarding one. And I know that, it's not an easy thing to do. So with that, we are going to excuse you. And again, I do wish to express, as sometimes a pattern instruction doesn't really fully express, our appreciation for the service and what you put up with while you serve on a jury. But we are going to excuse you. But again, if you do have any questions, you may remain. If not, you're free to be on your way. And I'll just note for the record that we kept the alternate until after I polled the jury. So then you can also notify, we'd like to give the information to Mr. Tyerman as well. And he can be excused if he wishes. And if he has any questions, then he can remain. Okay, so we're going to excuse the jury. All rise. All right, thank you. You may be seated. All right. Any motions?
Yes, Your Honor. Based on the verdict, the state has two motions it would wish to make. First off, we would move for a judgment of conviction based upon the verdict. Secondly, we would move to revoke bond at this point in time.
All right. Well, does the defense wish to be heard at this time?
No, Judge.
All right. Court will enter judgment on the verdict of guilty as rendered by the jury. And the court will also revoke the bond at this time. And Ms. McCandless will be remanded to the custody of the Dunn County Sheriff. And we will set a sentencing date. So we need a date. I'll order that a pre-sentence investigation be prepared. It is a mandatory sentence. However, there is a parole eligibility date. So we'll...
February 24th.
How about, we'll have the record for scheduling.
Standard in Dunn County, but in Milwaukee County, I've always asked for a court order that defense counsel be present during the pre-sentence interview. I have never been, no judge has ever declined to order that. I'm aware that the probation department would not let a defense lawyer in, but they will comply with a court order. And that, so I'm asking for that order.
All right, State, have any objection?
Well, I'm sorry. On that issue, no.
Okay, all right, well, I'd ask that you prepare the order. for the court's signature?
Usually if you just put it on the order for the pre-sentence, they'll comply,
that
but
too.
in case not, we can get something to you next week. That can go to DOC and it'll have Mr. Nelson's office.
Okay, are we on the record for that, Madam Reporter? Okay, so, but off the record for scheduling, kind of ways out there, February 24. Yeah.
Friday, February 7th is fine with the state, Your Honor.
Mr. Nielsen?
AAG Hahn is not available, but we should be fine.
Ms. Vishny, does that work for you?
Yes.
What time?
I'm sorry, I didn't catch it. Did you want all day or half day?
Oh, Your Honor, it might be better if we have more than a half a day, it sounds like. I think there are quite a few members of the family that may wish to be making statements, so it may take
Starting
more.
at 9 a.m.?
What's that?
Starting at 9 a.m.?
9 a.m. for the rest of the day, maybe, just to be sure.
All right, well, back on the record, sentencing this matter will be set for Friday, February 7, 2020, beginning at 9 a.m., and we'll reserve the rest of the day for this matter. All right, anything further, counsel?
Nothing from the state, Your Honor, thank you.
All right.
I just have a question. How do you want that ordered that defense counsel may be present for PSI interview?
Shall be present. Okay. Put in there, shall be present.
Okay, thank you.
All right, then, with that, we'll be adjourned. Thank you.